Are we good?
Madam Chairman, I think we're ready.
All right, good morning. We are at the April 17th Wyoming Stable Token Commission meeting. If you were on the wrong plane, get off now. I will go ahead and call us to order. And as we know, our fearless leader is briefly absent today. So let's go ahead and call the roll, please.
Can do, Madam Chairman. I'm just simply looking for a document that I did have here, and it was just a little buried. Thank you for your patience. Commissioner Meyer? Here. Commissioner Pope? Here. Commissioner Wallace? Here. Commissioner Naves?
Here.
Commissioner Revel?
Excused?
Commissioner Gordon?
Excused?
Chairman Racines?
Here.
Madam Chairman, you have a quorum.
Great. All right, well, I don't have any comments, so moving on to you.
Thank you, Madam Chairman. So first things first, we do have our agendas and sign-in sheets in, I believe, the back of the room, although it is a different room. So perhaps the sidebar. And hopefully the audio is a little better for the team here in this venue. So I will read our standard disclaimer. Key decisions pertaining to the Wyoming Stable Token Initiative will be made by the commissioners of the Stable Token Commission or the state legislature in public meetings such as this. Further, the only commissioners are those appointed by statute, the governor, or a majority vote of the commission. At this time, Wyoming stable tokens are not available for purchase. Prototype tokens with no backing reserves and therefore no financial value have been issued on test nets for the Ethereum, Solana, Avalanche, Arbitrum, Base, Optimism, and Polygon blockchains. These are for testing purposes only, and smart contract addresses are published on our website. As such, any website or platform claiming to sell or distribute Wyoming stable tokens should be considered fraudulent. Please do not attempt to purchase tokens from unauthorized sources. Information outside of these public meetings should only be considered factual and legitimate if it is distributed through our official channels. At this time, these are limited to our website at stabletoken.wyo.gov, the Wyoming Legislature website at wyoleg.gov, and our social media channels with the @WyoStable username on Twitter, YouTube, GitHub, and Warpcast. With that being said, Madam Chairman, I'm happy to review today's agenda and then get into the swing of things.
Proceed.
Thank you, Madam Chairman. I will quickly note that Commissioner Revel is also on the line.
Good morning.
Morning.
Okay, so on the docket for today, we're going to punt on the meeting minutes from our last discussion to the next meeting. They ended up being a little longer than anticipated, so we'll handle those in the next discussion. We will go through the monthly budget review, both in its standard format, and then I will introduce a new flavor of it that our CFO, Joseph Saldana, is working on. We'll give a brief verbal update on vendor negotiations and contracting, as well as the Procurement and Wyoming Public Records Act rulemaking, for which we are in the public comment period. We will work to reschedule the next monthly meeting of the commission due to a conflict with the Select Committee on Blockchain's schedule. We'll do a quick industry update. We'll spend some time on reserves management. We now have a final version of the reserves management rules that we would like to seek approval for and begin the process of regular rulemaking for those rules. We will go through a token testing memo. This is how we expect to test some of the features of the token and communicate that to the commission, as well as talk through a pilot program for onboarding users who are Wyoming residents or Wyoming domiciled entities to help us with that testing. And then go through the next update on the blockchain qualification exercise, where we are at that with submissions from first-party sources and what the next steps are for us there. Following that, we'll quickly wind down with next steps, discuss upcoming meetings and events, of which there are quite a few, and then we'll open it for public comment. Madam Chairman, we don't typically review or approve the agenda formally, so I'm happy to take any questions on the docket for today. Otherwise, we can move into the monthly budget review.
Go ahead.
Thank you, Madam Chairman. So for those in the room, you'll have 3 pieces of long paper in front of you. One might be folded up. For those on the line, you should have access to the Google Drive folder where these files exist under budget summary, and then the third one would be revised projections. The first one we will go through, it's kind of standard format, is the monthly budget summary. This is what I prepare as a kind of consolidation of the detailed information provided from the A&I team. As usual, the main driver of our budget is personnel, so salaries and benefits. That stabilized in January. It's been static pretty much since. And as a result, we were able to move funding from our 900 series, where most of our budget resides, to the 100 series for the rest of the biennial fiscal year. So we should be all set on headcount and payroll. For travel, we had another month where we had a bit of a higher expense. That was for my own travel to the DC Blockchain Summit for the fireside chat we did with Governor Gordon, as well as Deborah Brooks' travel to Frankfurt, Germany for the Digital Euro Conference. Beyond that, we have some recurring charges around telecom that also seems to have stabilized. Now the team has their phones and all the data plans are set up. And our total aggregate commission expense as of the end of March is $522,516. So of the 5.8 million we have available, that's 9% of the budget that we've spent over 9 months out of 24. Therefore, we have a remaining budget of 5.277 million. The remainder, or about 91%. That all being said, we can expect some pretty hefty changes to that in the coming months as we look to onboard our vendors and partners for the development of the stable token. Some of those fees will be paid up front. Plenty of them will be month to month, but we will expect to start burning a little hotter as we move forward. That's one of the reasons why I wanted to bring up the form that Joe has created. But before we get there, again, just to walk through the detailed spreadsheet. Again, this will be a familiar form to you. I've been seeing it for the last year and change. This is, if you were to look at, again, this document prepared by A&I, you'd see in the 100 series, we have projected expenditures of about 1.3 million. So that, again, recognizes that we know how much we're going to spend in that bucket per month. It's projected out for the year. And the A&I team has helped us allocate money from the 900 series to the 100 series to accommodate that spend. However,
Madam Chair, question?
Trish?
On the vendors, I mean, it probably is a mix of everything, but as far as, are we paying a lot of them upfront for a year's service? Are we paying them, I guess our attorneys are going to be by the hour, you know, but are any of these going to be volume-based or a combination or just kind of a little bit of everything?
through the chair, Commissioner Meyer, unfortunately, it's a little bit of everything. And that, I think, speaks to the broad swath of vendors we're looking to engage. So some of them, like our partners at Layer Zero, they've deployed smart contracts. Yes, there will be some support along the way, but for the most part, you know, this is static. We could plant a flag and say we did this. Here's the invoice. Legal, of course, is hour to hour and by resource. Many of these teams are working with, if we do need hourly support from a specific resource, which is fairly uncommon because we kind of know what we want to build up front. There are, you know, hourly charges associated with that. For the technical side of things, with some of the infrastructure we're looking at, there can be usage-based fees as well. So the negotiations we're doing are unfortunately not all that standard. It's highly customized for each of the 7 vendors that we're working with.
Thank you.
Madam Chair.
Go ahead.
On this, for the vendors still, when you projected the amounts, were they projected as a greater of lower amount or average or mean, or how were they projected? On the ones that are activity-based or volume-based?
Through the chair, thank you for the question. So again, in a minute, we'll head over to Joe's kind of high-level consolidated spreadsheet. But we certainly have some models in the back end where we're looking at potential growth metrics, and all the usage is based off of those potential growth metrics. The folks who are in the commission who are on our business planning working group, they've seen the largesse and the thoroughness of the models that Joe's put together, and I'm happy to share those with whoever wants to take a look. Madam Chairman, quickly returning to the detailed spreadsheet we received from A&I. Again, we covered the 100 series. I mentioned that in comparison, for the 200 series and 400 series, as well as the contract services in the 900 series, those funds are not yet allocated. So our team, myself, Joe, and a couple others will meet with both A&I and members of the budget department, including Director Hibbard, on May 1st to talk through the budget for the rest of the biennium, as well as get us set up for success for the next round of budget session for the BFY 27-28 fiscal year. So we start planning for that now. And again, this will be, to be quite candid, this will be my first time going through that process formally. Well, I did go through the JAC process last year. I was brought on in December of 2023. So by the time that I got my feet wet, that process, the budgeting process was functionally done. So there was a lot of effort put in kind of manually to kind of get us where we needed to go, and we got it done, which I'm happy about. But this will be the first time we actually have the ability to kind of prepare ahead of time with the support teams and go through the formal process. So there'll be more detail about that on the way as I'm learning as well. Okay. And last thing I will note on the finances then, again, you have a large piece of paper. This is a high-level overview of the model that our CFO, Joseph Saldana, is putting together. What we want to do with this model that is not captured in some of the other models we presented before is go through month to month and do the projections that way. So you can see in this case, we are looking at various fees for contract services between this April and June 30th of next year. Those are all, so they are different numbers. Those are informed by the actual negotiations we're having. So again, this is not on, it's not shared publicly. The commissioners have a digital copy of it, but this is based on the negotiations that we're having, the payroll that's kind of locked in, anticipation of additional travel, and a consolidated version in the bottom left here. So again, this is a high-level version. There's a couple of pieces of cleanup we have to do, and I would expect this to be in good shape for kind of a formal presentation next month once we have all the vendor payments locked in, and hopefully those contracts are done and finalized. We'll have final numbers. Joe and I will go through and make whatever tweaks we need to make, but I would expect that in the near future, our reviews will be looking at something that's more like this than and customized for what we're doing specifically.
Anthony.
Commissioner Naves, the chair.
Yeah. For folks that are accessing the documents in the Google Drive, is this title Revised Projections? Is that the one you're just speaking of right now?
Yes.
Okay, thank you.
I'm happy to take any other questions or comments on the detailed variance analysis. And if there are no questions, through the chair, we could quickly just recognize Joe if he's got any other additional context to add.
Just one minor comment regarding Commissioner Pope's inquiry. So we ran multiple analyses and scenarios surrounding all the vendors. We put a worst case, medium case, and best case, and we analyzed all the vendors' flows, whether they're recurring or non-recurring, and for how long of a period that is, and that's incorporated into the variance analysis that Anthony has just shared with the commission. In addition to that, we have other models that are looking at the cost associated with with other moving variables to see what the impact will be on the financials.
Go ahead.
Thank you, Madam Chairman, and thank you, Joe, for putting that together and for all the other models you've put together, which is certainly appreciated because we're going to be tracking this pretty closely as we move forward. So if there are no further questions or comments on the monthly budget review, next thing on the agenda is a quick discussion around vendor negotiations and contracting. So just to kind of go all the way back, the executive director was empowered by the commission to enter into negotiations at a prior meeting on February 27th. Since then, we have held negotiations with all the top ranking parties that we did our interviews with and went through the procurement process. We have engaged Layer 0, so we had a bit of news about that. We do have test tokens through the Layer 0's token distribution platform. on 7 different test nets, which is great. More to come on that in a few. And we also have engaged Inca Digital Federal for open source intelligence. That's one of the platforms to make sure that nefarious actors are not using Wyoming stable tokens. In terms of the status for other contracts, I'll be a little bit high level here because again, negotiations are still ongoing. But of the remaining 6 parties that we are seeking to engage, I think we're going back and forth with contract and SOW comments with 4 of them. So I think we're in pretty good shape. One more thing I'll quickly add, and this is not secretive or furtive in any way, but with our negotiations with Franklin Templeton for the reserves management, as part of that discussion, we are looking to draft a investment policy statement as well as execute a investment management agreement wrapped inside the Wyoming state contract. So just that's a quick FYI for those who are familiar with those documents. And also just I wanted to quickly thank the Treasurer's Office for all of the input along the way on helping craft some of those documents. Any questions on the vendor negotiations? No, recognize we need to be a little bit high level about it.
Go ahead.
Thank you, Madam Chairman. So next item on the list, procurement and the Wyoming Public Records Act rulemaking. So as a reminder, these were approved by the commission some time ago. We got to the session. We have finally had a chance to push these public. So these are in a public comment period, which is statutorily required to be 45 days. We've put it for 46, so we kick that off on Friday. We messaged it appropriately through a advisory that came out through the governor's office, so to have that full mailing list in conjunction with the alert for and the public notice for this meeting. We also separately, Steph helped set up a Wyoming stable token distribution that went out to about 1,300 people that also mentioned some of our updates as well as the rule period being open. For those who are interested in providing public comment on our procurement or WPRA rules, we are facilitating that all through our website. There's a big banner right at the top. You can fill out the form. It's all automated and it'll ask you what chapter of which rule set you're looking to opine on. And then we will review that feedback once that period closes after May 27th. And then we'll go through the rest of the formal promulgation process, which requires collaboration between the Governor's Office, Attorney General's Office, Secretary of State, Management Council, so on and so forth.
Director, I should know this, but what is the timeline on our emergency rules? When do they expire?
Madam Chairman, they have already expired.
They have already
So we're
expired.
covered by the fact that this process started within the context of that. So we can't start a new process, can't start a new RFP under
Okay.
our emergency
So-
rules.
Okay, gotcha. Thank you.
Any other questions? Moving on to the next item, rescheduling our meeting next month. So we have on the calendar our next meeting to happen on the morning of May 15th, normal time, had been planned in Cheyenne. However, the Select Committee on Blockchain this year has adopted, instead of their traditional Monday, Tuesday split, they are now doing Wednesday, Thursdays. So we are going to have our commission meeting smack dab in the middle of day 2 of the Select Committee on Blockchain's meeting in Jackson. Being that we have multiple commissioners who are the governor's serve as the governor's liaison to the Select Committee, and I've also been asked to be there in person to provide testimony more than once on more than one topic. I believe it would probably behoove us to move that meeting. I'm aware that there's additional travel within the governor's office and beyond during that week and the next. Following a conversation with the governor's office, it was recommended we try to plan that meeting for May 30th after the Memorial Day weekend. I think when we have a conversation around the pilot program and some of the other things we're doing, it might make a little bit more sense to have a bit more time before the next meeting, still meet in May, but give ourselves an extra 2 weeks. And again, if there's any kind of big, any additional remit, any kind of ask that come from the Select Committee while in Jackson, we'll have time to triage that before we meet, rather than trying to front run a meeting, just to front run a meeting, or to try to do things concurrently or shortly after. without time to be reactive and thoughtful about what we might be presented with.
So Director, I'm making the assumption that that date's clear for the governor.
I'm sure that's correct.
I'm free, as everybody else.
Sorry, which day is that? The 30th?
Yeah.
This would be Friday, May 30th from 9 to 12 in Cheyenne, to be clear.
That's fine.
Yeah, just so we. Great, get it on the calendar before we,
So yeah.
Kurt,
if
how
we
are you?
have a quorum, and for the commissioners on the line, I want to make sure we recognize you as well, if that date works for you, or if you want to just let me know shortly hereafter, that's fine as well.
What is the
Works
time?
works for me. Sorry, Flavia. Yeah, it
No,
works
no,
for
no.
me, Anthony.
Yeah. Is it at the regular time, Anthony?
That, through the chair, that would be the intent, Commissioner Naves, 9 to 12.
Okay, that works for me then. Thank you.
Thank you, Mr. Treasurer. Okay. Sounds like we can move on from that. So thank you for your flexibility. Any other questions on the updates and approvals before we move on to the stable token industry update? Moving forward, the stablecoin market cap currently sits at about $227 billion. We're fairly close to the all-time high of $234 billion. That is up 42% from about $160 billion last year. And at this point, the 30-day moving average of stablecoin transaction settlement on all networks is about $2.1 trillion, which is a substantial amount. In terms of things we're tracking domestically, again, we continue to track what is happening at the federal level. That includes both the Genius Act in the Senate, which passed out of the Senate Banking Committee in mid-March with an 18-6 vote. So that is going to head to the floor of the Senate. Likewise, the Genius Act, which is the bill in the, I think I flipped them around. The Genius Act is in the Senate. The Stable Act is in the House. That also passed through their Financial Services Committee in early April. And that last meeting of the House to clean up the Stable Act was to largely put it into compliance with the Genius Act. So when those head to the floor, the assumption that there'll be less colliding of both series of documents. The goal that we've heard from Congress as well from the president is they look to have this done before the August recess. So if we intend to get ours out in June, or July rather, be a bit of a foot race. But that is the status of those. I will just also mention that in both acts, now that the Stable Act has been somewhat hybridized with the Genius Act, the way they define issuers of stablecoins is as a person. And I don't necessarily see ourselves in that position. It describes banks, trusts, other business entities. States are not necessarily listed in there. So I think we're still outside the frame a little bit. So we'll continue to monitor that along the way. Another kind of key federal discussion that's happening is the SEC's actions. Their Division of Corporate Finance put out a statement on stablecoins earlier this month. They now have a term called covered stablecoins, which is meant to be defined as US dollar-backed stablecoins with a one-to-one backing and a low-risk basket of reserves. These are not considered securities. Covered stablecoins are marketed solely for use in commerce as a means of making payments, transmitting money, and/or storing value, which has always been our perspective, and not as investments. There is also an interesting footnote to that document, footnote 4, which states the SEC does not express a view regarding the application of federal securities laws to yield-bearing stablecoins, which are stablecoins providing holders with yield, interest, or other passive income, whether in the form of regular payments or rewards, or in the form of rebasing, which is a mechanism that automatically adjusts for the supply of the stablecoins. So they're still remaining silent on that topic, while they're saying that covered stablecoins, one-to-one, nothing, kind of vanilla, not too much flair, not securities. You start adding things to it, we might have to take a different look at it. That's where that stands currently. Last piece of domestic news, and I'll put air quotes about that, because I had not heard of candidly, the Northern Marianas Island, nor the municipality of Tinian, but apparently they had themselves intended to launch a Tinian stable token as part of a bill pertaining to online gambling and casinos. But that was vetoed by their governor. So we're still the only
We
one, as far as
almost
I know,
got beat by the Northern.
a municipality
Alliance.
within a territory. So that was interesting to see. Any questions on the domestic news? Commissioner Naves, I would certainly turn it over to you if you have any other further thoughts, or Deb, any other further thoughts on the SEC statements that I may not have covered.
Thank you, Anthony. No, as you shared, we're seeing a lot of activity coming from the SEC, not only Corp Fin, but we're also seeing the commissioners actually making direct statements about whether certain activity falls within the realm of securities laws and will be considered investment contract or anything else. So there's certainly a lot of interest from that agency in looking for ways to facilitate this industry's activity while at the same time ensuring that regulation applies where appropriate. There have been several roundtables held by Commissioner Pierce recently discussing several topics in this industry, and we should expect to see additional statements or potentially regulatory changes arising from those meetings. Overall, very positive meetings, a lot of conversations that are generating good thoughts and a critical look into the existing approach and what should actually be done to ensure that investors are protected. Ultimately, the concern is protection of investors, not necessarily just minutia of potential filing issues. So overall, very positive. And yeah, and the statement around stable coins and what means a cover stable coin. And their specific statement that yield generating stable coins are not part of that analysis. And to your point, Anthony, remains to subject to further review, is something for the commission to be aware of, as the commission may explore down the road alternatives or other features for the Wyoming stable token. So I ask, the executive team through our Chief Risk and Compliance Officer to continue monitoring these regulations with the assistance from the Attorney General's office as well as outside counsel, and informing the commission of any relevant developments and whether we need to propose any adjustments to the select committee on how our commission works or the laws pertaining to the issuance of the token. But thank you, Anthony.
Yeah, Madam Chair?
Go ahead.
I have a question, Flavia, about whether or not if the state bought stable coins and we put them on deposit with a financial institution, what percentage could the bank or the financial institution lend against them?
There's no disposition around that in the current proposals. So what this proposal is, the Genius Act and the Stable Act are, Kurt, is more a framework for regulating the issuance of stable coins. Then you would need to have the Federal Reserve in conjunction with the OCC and the FDIC for federally regulated entities and the state regulators for state regulated entities to come up with any parameters around permissible investments and how these funds are managed. So that will come with that. So unfortunately, right now, there's nothing on that point on how the banks or the reserve managers will be able to manage this. It does dispose of where the reserves can be invested in, right? So it will be treasuries and overnight repos and things like that, very conservative investments. But it does not go further into management within the bank. So if you have anything cash that is liquid sitting in a bank account for immediate redemption, it doesn't dispose of that in particular.
On the title of the token itself, if you had it on deposit, do we have to get into the UCC as far as the who has the title of the asset?
So we actually, that's a very good question, Kurt, and we have a thread with outside counsel through the Attorney General's office. The legal subcommittee has that conversation going on right now, and we will hope to report to the commission in short order. But we have the AG's office and outside counsel looking at UCC applicability to our activities and to
Yeah.
what extent that would be.
Yeah, it's kind of a different deal because you have an asset that's backed by, you know, the state, and if the state bought that asset from the commission, basically, then the asset is you know, guaranteed by the purchase of the treasuries. But whether or not there'd be a window through I guess the veil of the token as to whether or not the underlying, I guess, securities or treasuries would be, you know, available to anybody else except for the owner of the token, if they wanted to redeem it. So yeah, there's a lot of moving pieces in there, so, and a lot of questions that we might be able to get something together at a state level that would be functional, that perhaps at a later date, someone else could take a look at it at a larger basis. But I'm not contemplating anybody buying stable tokens and putting them that wasn't the state and putting them on deposit. I think that's something that's a bridge that's way too far. But discussion.
Yeah, we'll certainly ask the legal subcommittee will certainly ask the Attorney General's office to report to the commission once the review with outside counsel is completed on UCC applicability to this activity.
Any other questions for the director?
Madam Chairman, I just quickly invite Ms. Brooks, if you have any thoughts or comments about the SEC statement, just to rewind a few moments here. Want to present that opportunity as well.
Thanks, Anthony. I think Commissioner Naves summed up pretty accurately. We're monitoring internally. We've had communications for some time with outside counsel and the Attorney General's office. So I think thanks to Commissioner Naves, I think she's adequately summed up what we've been doing on the back end.
Thank you, Ms. Brooks. So to quickly just cover off on two last pieces of news here for some of our incumbents with a bit of an international flair as well. Circle did announce a IPO, filed an S1 to go public on April 1st with JP Morgan and Citi as underwriters. However, my most recent understanding is that has been or may be delayed due to some of the recent economic uncertainty in the markets. So not clear if that's moving forward at this point in time, but we will continue to look at that. And then second piece here is Visa has joined what's called the Global Dollar Network, which is a consortium of a number of different organizations, including Kraken and Robinhood, but it's issued by a subsidiary of a firm called Paxos that is in Singapore and overseen by the Monetary Authority of Singapore. So looking to see what happens and how that works from an international standpoint once all the parties are at the table and integrated. Any other comments about that news, specifically anything that people have heard that I didn't mention that you wanted to cover off on stable token related?
Are any of these people that are brokers in crypto or in stable tokens that are trying to get their own, I guess, token or something set up? Do you feel like they're trying to, I guess, lock out competition in any manner that would be antitrust in nature?
Through the chair, I would be hard pressed to think any of this could be antitrust related. When I think of that, I think of,
Well, I guess if a brokerage refused to have our token on it and they had their own token and they basically said, well, we're going to use our token and not your token. You know, I mean, it sounds just like some of the Google things that Google's gotten hit with on antitrust to me.
Through the chair, that's a great question. I don't have a good answer for that. You know, what we're seeing now is a pretty rapid proliferation of stable tokens. Lots of organizations trying to add their own flair to it or integrate it into their own offerings for, you know, faster settlement, more visibility or traceability, what have you. They've all got their own reasons, but, you know, the returns are certainly one of them. I think at this point, Tether alone and their treasury holdings would put them as like the 5th largest or 8th largest holder of US debt, like if you put them against the foreign holders of US debt. So it's a significant amount, which means a significant amount of returns. And I think, you know, people are certainly chasing those dollars to the extent that people are locking other tokens out of platforms. I think it's going to be an interesting couple of years to figure out what that's going to look like and how the law will handle that. But we can certainly flag that on our side and explore.
Yeah, thank you.
Go ahead.
Anthony, I understand the discussion with the SEC on the stable coins as far as not being securities, but it seems like I heard something about, they were talking about interest-bearing stable tokens, and there's kind of still a question on those. Do you have an update on any of that?
Yeah, so through the chair, Commissioner Wallace, the quote I read, and I'm happy to repeat it, is from the actual SEC statement, which is to say the SEC does not express a view regarding the application of the federal securities law to yield-bearing stablecoins, which are stablecoins providing holders with yield, interest, or other passive income, whether in the form of regular payments or rewards, or in the form of rebasing, which is a mechanism that automatically adjusts the total supply of the stablecoins. So it's a lot of words to say TBD, is how I read that. They're gonna be silent on it for now.
That's probably, we just kind of have to sit and wait and see what the market does with that. Okay, thanks.
And then, Madam Chairman, also noting a hand, Deb, I think you had a hand up on the screen. I don't see it anymore, but.
Yes, I just wanted to follow up on the question that the commissioner asked from an antitrust perspective. Being a former antitrust attorney myself, I think I can understand the concerns with exclusive dealings and tying arrangements that could potentially, I'm not indicating that's happening in this instance, but it could potentially be ongoing on the back end, whether it's a potentially civil antitrust or criminal antitrust enforcement. That remains to be seen. I'm sure the antitrust division, US DOJ antitrust division, which I served in that agency for a long period of time, a long time ago, would likely, if prompted, would look into it and investigate. So that's something that they would be monitoring to ensure that there is no back-end agreements. But to your point, you are correct that there may be some antitrust concerns, because as I look at these agreements, I too have antitrust-related concerns as well. But again, I'm a former antitrust DOJ attorney. I'm not speaking for the DOJ at this point whatsoever. Anthony. Yes, Commissioner Revel?
I think we lost audio. Can you guys hear the
That's
floor?
because I didn't follow steps and instructions to turn the microphone green before I started talking into it. Commissioner Revel,
Thank you.
a comment, please.
Thank you. I actually wanted to go to a separate comment. So I just want to make sure Ms. Brooks' comments were, if anyone wanted to respond directly to that, I can wait.
I don't think anybody did. Go ahead.
Okay. Thank you, Madam Chair. Yeah, I was hoping to go back to the comment about the SEC clarification and sort of discuss that about what they defined as covered stable coins, and created a lot more clarity on what a covered stable coin is, and that clearly stating that it is not a security. Director Apollo, I read that a little bit differently with regards to interest, where they did not provide specific clarity in the verbiage that you read, but elsewhere they do say that a covered stablecoin does not entitle a holder to the right to receive any interest, profit, or other returns, and that covered stablecoins are marketed solely for use in commerce, et cetera, and not as investments. So I would be curious for your view, or any of our legal experts here, their view on it. But to me, it sounded more like a pretty clear statement that interest-bearing or return-bearing stable coins would need to go through a process with the SEC or a registration process as a security.
Madam Chairman, I'm happy to take the one on first, and then happy to turn it over to Commissioner Naves or Deb. Point well taken. Again, I'm reading directly from footnotes here, so I think, with due respect to the commission, the Securities and Exchange Commission, that is, this might be trying to have their cake and eat it too. They're going to say covered stable coins are going to be quite vanilla and not include these things, but we're not ready to say yet that these are securities, because that opens up a whole nother discussion that they may not be quite ready to have yet, while they're going through a period of pretty significant staffing and perspective changes. So this might be a way for them to kind of keep multiple irons hot while they're getting more formal guidance together in any direction. They may even be coming up with new filings for stable coins that are yield or interest bearing, right? We don't quite know yet, but I think they're trying to come down the middle, and the fact that you and I are both quoting from the same document in different places and essentially reading different things, which both require a slight amount of interpolation, I think kind of sticks us right in the middle. It's my own personal perspective.
I don't want to speak on a legal position since I'm not counsel for the commission. Do we have Devin or anyone else from the Attorney General's office, Anthony, that can speak to this?
Through the chair, Mr. Kenny is in the room. He's more than welcome to join, but this is more of an SEC matter than a stable token commission matter, I would think, at this point.
A point of information while he's coming up, are there like classes of stable coins, covered stable coins, other kinds of things that they call stable coins? I was hoping we got rid of those logarithmic instruments and that they don't call those stable coins. Are they still doing that?
So through the chair, Commissioner Meyer, there's still references to algorithmic stable coins in the footnote that I read, a little like 2 sentences beforehand. They're still talking about algorithmic stable coins, right? When they talk about other types of stability mechanisms, and that is one that is technically based or involves these rebalancing mechanisms rather than a fiat backing. So we're not touching that. I do know that the federal legislation around stablecoins, not the SEC statement, but we start talking about the Genius Act and the Staple Act. At least one of them, if not both of them, has a 2-year moratorium on the issuance of algorithmically backed stablecoins until further research is done. And if you recall the conversations we had last year about the Lummis-Gillibrand Payment Stablecoin Act, very much the same there. It's a little bit of a third rail that will take a little bit more time before anyone wants to touch.
Yeah, I just hope that they come up with another name for a logarithmic stable coin, because it's not stable, maybe just say coin. Yeah.
Commissioners, Commission. So this is Devin Kenny, the Attorney General's office. I think, and this is certainly not, we in order to make like a more definitive statement, we would need to actually do a heavy bit of research. I mean, I don't know how extensive it would be, but we would need to like look at that question and specifically try to answer it. Off the cuff, I have read it. My general thoughts would be kind of between the director and Commissioner Revel's thoughts. It's essentially that both points are somewhat accurate, that the SEC is not taking a firm position, likely for the reasons that Director Apollo has stated, that they don't want to put themselves out there too far, but at the same time, that the reason that they're doing that they don't want to take a definitive statement is that they probably are thinking of them as being securities, but that they don't want to necessarily, I mean, if they wanted to just make a statement, they would have done it, would be kind of my thoughts. I haven't talked to them, but I would assume if they want to do that, they would have just done it. They didn't. So to me, that implies that was for a reason. My guess is that the reason was because they didn't want to go out that far. But they also could have just as easily gone the other direction, and they didn't do that either. So my guess is that both of those things are true, is that they are thinking of them as securities, but that they don't want to make that statement at the moment, for whatever reason, internally.
So some of my friends are for it, some of my friends are against it, and I'm with my friends.
Precisely.
Yeah, okay.
Commissioner Revel, did you have something more to add?
Thank you. I was hoping to just ask an additional question, Madam Chair, if that's okay.
Go ahead.
I'm just curious, while we're on this topic of this SEC statement and their clarification, would we be well served to more clearly specify that the Wyoming stable token is a covered stable coin under the SEC definition as we're presenting this to the market, to make clear that we understand the SEC's clarity and our intent is to have this be a covered stable coin and therefore not subject to securities treatment as a security and I think that's what we're doing in effect, but do we want to be more clear about it in our communication with the market and with regulators?
Go ahead,
So,
Director.
Madam Chairman, through the chair, Commissioner Revel, and noticing that Commissioner Nava has a hand up as well. This is something that we've certainly been discussing internally through the legal working group subcommittee. This is something that we'd expect to have a memo on at the next meeting in May to go through some of this, particularly around definitions. Again, the covered stablecoin is a new term. To the treasurer's point from just a moment ago, we even have discussions internally about what the term yield means or interest means in a digital asset context, right? Is it the yield you get from staking Ether on the Ethereum blockchain? Is it yield that's being passed on to you because, stablecoin issuer X makes money off treasuries and just passes it along? Is it something that looks a lot more like the Coinbase earn model? These are all different things. They're all called yield in some way, shape, or form. So we're looking to kind of create our own vernacular around some of this to clarify, and then use that as a jumping off point of discussion for the commission, which would be the ultimate arbiters of, how we want to market this token, how we want it to be structured. As of right now, everything is up for discussion, but I would look to have that as a fairly key topic at the meeting next month, which is also one of the reasons why I wanted to have it as its own standalone thing. Recognize it might be a lengthier meeting with some fairly nuanced discussions around that. Again, recognizing that Commissioner Nava has a hand up.
Thank you, Anthony. So Joel, we will have to have Devin and our outside counsel provide guidance on whether adopting a definition that is being provided by the SEC could potentially impact the state's position on not being subject to federal laws around the issuance of securities. So this is one of the things that we need to think of, and that the memo will be issued to the commission for consideration. But yeah, we're thinking about that.
Great, thank you. I have no further questions, Madam Chair. Thank you.
Anything else? Go ahead.
Thank you, Mr. Kenny, and thank you, Madam Chairman. So moving on to our next topic of discussion, which is going to be reserves management and the rulemaking for that. So this morning, you've got 3 pieces of paper in front of you. One is the regular reserves management rules memo, bit of a tongue twister. We have the packet of the actual rules as drafted. And then we've got a red line copy from the last time this was presented last month. So you can have a more granular idea of where these changes have been made. So we've put this in front of the commission a few times at this point in various instances. We've had a lot of great review and feedback on it. And net where we are right now is we'd like to walk through the reserves management rules as drafted, explain where some of these changes happen, go through again what we're trying to accomplish with this. And if it's the will of the commission, try to get this approved by the commission for pursuit by the executive director and commission staff of regular rulemaking for these rules. So the memo we could just go through super quick because I think most things that are in the body of this I'll want to highlight in the document itself. But again, this authority that was granted to us by the statute covers multiple sections. If you were to just go down to the bullets on the front page of which sections those are, you'll see that what we're trying to get towards is rules around redemptions, creating things like a trust account and making sure the money is flowing appropriately, no limitations on liability, et cetera. So, and one quick call out at the bottom of page 1 is the goal for this is to be focused on reserves management, right? Dollars in, dollars out, tokens in, tokens out, and the financial pieces and movement behind them. What these rules are not meant to address is what happens at the blockchain level with the technology. That'll be a separate rule set that perhaps may even be drafted for a very preliminary, FYI type of review at the May meeting as well. So moving on to page 2, we actually have a discussion around the rules. We're looking to establish clear, understandable standards that bolster the sufficiency and transparency of assets backing the Wyoming stable token, raising consumer trust while fostering a secure environment for innovation within Wyoming's expansive digital asset ecosystem. And to that extent, I want to just quickly shout out the participation that went into drafting these. These were led, Deb has led the charge on this, but we've received input from the agency resources, 3 of our commissioners, members of the state treasurer's office, members of the attorney general's office, the regulatory support team at Paul Hastings that we engage, and we had multiple subject matter advisors tag in as well to provide their input and support on this document. So in terms of how the rules flow, chapter 1 is general provision, so that's going to be your definitions. And we also have some authorities proposed to be granted to the executive director and team that should make the day-to-day operations a little easier. Chapter 2 is on the issuance of WIS, so when dollars come in from licensed service providers, Wyoming stable tokens go out. Chapter 3 is the reserve asset management piece, where we really work to define what we refer to as the cascade of flows when we start generating dollars off of those treasuries that bear interest. When those dollars come back to the state, where do they go? How do they go there? When do they go there? And who flips the switch? And then chapter 3 is redemption, right? So functionally the opposite of issuance, instead of dollars coming in, tokens going out. With redemptions, tokens come back to us and we return US dollars to a licensed service provider. Again, the analysis piece just highlights some of the key differences between this version of rules and the one was presented back in March. But what I'd like to do is just go through the actual rules. Again, I think everyone's seen this a couple of times at this point through the previous meetings, so we could be a bit more breezy about it. But before I start going through and reviewing specific sections that I think bear a call out for informational purposes, Deb, I will once again turn over to you through the chair and see if there's anything you wanted to add before we dove into the substance of the document.
Nothing to add. Thank you, Anthony.
Okay. Thank you, Deb. So we'll go through these again. We're not going to read it line for line, not even section by section necessarily, but we'll just call out certain things that we believe are important. So in terms of the chapter 1, general provisions, we have definitions. You could see in section 3, subsections E and F, as well as in J and K. Those are kind of the parallel methods of issuance, submitting an issuance request to the commission and then being issued stable tokens. And then same on the other way out, we have a parallel process. A redemption request comes into us, tokens come back, and the dollars go back out, return to the LSP. Another one that I wanted to highlight is subsection H. This is what we call the liquidity fund account. We brought this up in the last discussion, but bears some repetition. While the statute allows us to open a trust account, the trust account is definitionally the account that will hold the one-to-one reserves for Wyoming stable tokens, right? So there's 100 million stable tokens in circulation. That trust account is expected to have $100 million of cash and treasuries in reserve. But we know that we're going to be accruing interest on the underlying reserves. That has to go somewhere. So what we've done is we've created this concept of a liquidity fund account as a segregated account specifically meant to capture the buffer over and above 100%. So that's in its own kind of carve out, and we don't touch the trust account as we're trying to build that reserve up. Mr. Treasurer, you may have a question.
Yeah, I was just thinking, so I think you explained it, and that was, my question was that essentially every day you have overnight repos, you skim that off and that goes into the liquidity account.
That's correct.
Yep.
Sure. So one other key add that we had here, and this is a lot of wording for potentially a rare situation, but it's an important one. In subsection Q, we've defined the term unavailable as it relates to a licensed service provider. So essentially, we're creating a very stringent set of circumstances and situations in which a licensed service provider, who we're expecting to be the reseller of a Wyoming stable token to an end user, goes bankrupt, goes deficient in a material way, is no longer, they're not going down a couple hours for maintenance, they're off the grid. And then people, the end users, what we call token holders, may have some amount of Wyoming stable tokens, and they're just stuck with them. And the licensed service provider they receive those tokens from is no longer available to perform that redemption. In such a case, and this is highlighted in Chapter 4 in detail, we have a scenario, this break the glass kind of emergency scenario, where a token holder can seek redemption directly from the commission. Again, that should be a rare instance. It is a very specific set of circumstances. Generally speaking, token holders, individuals, the retail users, should be going back and forth with these licensed service providers who could be, yes, it could be the big exchange, but it could also be payment platforms or other API integrated rails. But we thought that was an important one to add because sometimes these things do happen. We want to prepare for some of these more out there edge cases and contingencies. The last definition I want to highlight is WIST in circulation, which is the total supply of WIST that the commission has a special obligation to redeem, specifically on blockchains approved by the commission. So with that said, that's all of our definitions. Before I turn over to the limited delegation of fiscal authority, I do know Commissioner Navez and Deb, we had a couple conversations around some of these definitions that I highlighted. Just want to give you an opportunity to speak to them if need be before you move on to the delegation of fiscal authority section.
Thank you, Anthony. I think the concept of unavailability of the licensed service provider is critical for the proper functioning of this token because there could be instances in which these exchanges or resellers are not online, but they are still functioning as entities and the license holder could redeem through them. Should the commission elect to allow for redemption directly through the state for any instance of unavailability of a reseller, we are going to be posing substantial stress into the system by having to onboard each one of these token holders. As a reminder, redemption of tokens must be done through someone that has already been identified either by the state or by a reseller as someone that is eligible to engage in financial services activity, which means that person has gone through a Bank Secrecy Act approved KYC process, including sanctions screening. So we would need to screen each one of these token holders to ensure that they're actually able to redeem, and that will put substantial amount of stress into the process right now. This is the process that is followed by other issuers as well that only work through partners. And so it's something that the industry already recognizes as practice. So we shouldn't anticipate token holders to be surprised that this is the process that is to be followed. But it's something that the commission could review, not only now, but down the road, as the processes harden on our side and we're able to accommodate a direct retail interaction to be able to allow for other instances of redemption. But the working group that has come up with this process has put a lot of thought into it, and I believe that we have come up with a solution that meets the needs of token holders, ensuring that they are able to redeem with speed, while at the same time not putting stress into the system. Deb?
Thank you, Commissioner Naves. I concur with what Commissioner Naves had said. I would also add that, as Commissioner Naves noted, a lot of thought and attention has been put into what is unavailable. We, in placing this, and I believe Executive Apollo will go into it in detail later, to ensure that not folks, if a particular reseller or licensed service provider goes offline even for a day for whatever reason, that won't trigger a run to the commission for redemptions. So it is a break the glass approach, but it's very limited to who is eligible and the circumstances in which they are eligible to break that glass. So it's not in the case, for example, where a entity or reseller goes offline for even a few days. It has to be more substantive, and it does require some form of judicial action before the commission will take those steps to redeem.
If there are no other questions.
Madam Chair? Just one, thank you. Just one minor thought under Romanet 6 there. For clarity, the term unavailable specifically excludes any technical unavailability. Do we want to put temporary technical unavailability? Because the LSP could just maintain for weeks and months on end that it's a technical issue, and that may, in my mind, alleviate that.
David, what do you think about temporary? How do you define that? Because temporary then becomes very subjective to each person's interpretation, and then we could be opening the door to different inquiries that we may not be prepared for. So what would you think the temporary? What is the appropriate window for temporary?
No, I think that's something that we need to determine, but
Okay.
it's really a matter of discussion, maybe in another group. I don't know. My thought is that if it extends beyond a week, it is a problem for both us and the token holders. So take that as you will, but again, I want to avoid problems for both us and the token holders in that. If we're going to provide this window, we should define the window.
Can I add to that, Director?
Through the chair, please, Ms. Brooks.
Oh, thank you. Thank you, Commissioner Pope, for your question. I would add that even if it's the word voluntary or temporary is not really relevant for our purposes, only because even if it's short or long term, that doesn't necessarily mean that a retailer can approach us for redemption. Again, the break the glass scenario has to happen under very precise circumstances that's laid out in Chapter 4 of the draft, where they would have to come to us with some form of a court order or a judicial paper directing us to break the glass. So we're not just breaking the glass merely because we're being told by a retailer, for instance, that this particular licensed service provider has been unavailable for a day or a week or a month. our response would be to get some form of a court order or a judicial paper before we can break that glass. I don't know if that helps with or clarifies your point.
Madam Chair. Thank you, Ms. Brooks. That clarifies it quite well, and I appreciate that. So let me just, for further clarification, let me go through the process. The LSP goes offline for whatever reason. And it reaches a critical length of time, whatever that is. Then the retailer or the token holder would have to take some type of legal action against the LSP. And then we would be informed and make the decision whether to whether to redeem directly. Is that kind of the process you're seeing behind this?
Through the chair, that's pretty much the process that I've observed through other bankruptcies that I observed through my time at my previous agency in New York, where we did see an action by token holders who sought to receive their monies back. It's typically not always, but it's typically by that scenario in a bankruptcy setting, where it's the determination of the bankruptcy judge to divvy up the assets how that judge sees fit. So I think to your question and to your point, what we are envisioning in that scenario is we have to receive some type of order to break the glass. So it's not that the commission will necessarily get a complaint from a token holder or receive word from a token holder that a licensed service provider has gone under for how many days or months or permanent. The response would be, I believe, from an agency perspective, is okay, you need to go through a legal process by which we are being ordered to break the glass.
Madam Chair. Thank you. That resolves my question, and I don't believe that we need to add the word temporary then.
Madam Chairman,
Go ahead, Commissioner.
looking at a lot of that, I think we could put in our licensing agreements, you know, as far as the restrictions and what happens in the event that the licensed service provider, you know, is unable to perform the duties that we set forth in the licensing agreement. Then, you know, we actually say that that all these things have to go through a court system, you know, or we get some indemnity and I guess hold harmless or indemnification. I know a lot of the contracts that we used to have in different things when we were supplying different products, you know, there's a limit to what our liability was. It wasn't over the price of the product at any time, but yeah, looking at the terms of our licensing agreement, and getting a really good licensing agreement that gives us protection, lays out these circumstances about breaking the glass in these circumstances or whatever. So it's all there. You put some meat on the bone. So if any of these things get to a bankruptcy court, you've got some rules that the licensed service provider that has to play by. And if they broke those rules, then, you know, it's on them and not on us, more or less. I mean, we just got to get those folks to really give us some good contracts, agreements. Thank you, Mr. Chairman.
Madam Chairman, if I could just revisit one more topic here, and not to put anyone on the spot, but Commissioner Revel, one of the comments we wanted to go back and forth on was just wanted to confirm rather that you were comfortable with the definition of repurchase agreement. The goal here from the team was to have repurchase agreement defined as a term that would encompass both repos and reverse repos. Because we say the contractual agreement to sell securities to another party and a simultaneous agreement to repurchase the same securities at a predetermined price at a specific time in the future. I think we're relying on that simultaneous agreement piece, but wanted to run that by you before we moved on with this.
Madam Chair, with your permission, yeah, Director Apollo, I think that's fine to encompass both repos and reverse repos under the same definition and just generally refer to them as repurchase agreements. I just want to make sure that the language is encompassing both repos and reverse repos. The definition, because they are, obviously, while they're the same concept and mechanism, they're moving in reverse directions. And I just want to make sure that we don't exclude the ability to engage in reverse repos by not clarifying exactly what it is. That's my only thoughts on that.
Thank you, Commissioner Riville. So I think, is there any other thoughts on that particular definition? I know from the conversation I was part of, the group that I was with felt comfortable that that language as drafted does achieve that. But again, if there's any sensitivity around that, now is certainly the time to bring it up.
I'd say go ahead.
There's no other comments. I will continue driving forward here. So getting back to chapter
Madam Chair.
1.
My apologies. Just one other question on, under R, on the definitions. We use the term virtual currency. I know that's the term that's in statute. Will it require a statute change to change that? Because this is not a virtual currency in my mind.
Through the chair, Commissioner Pope, I regret to inform you this is based on statute, not what's in your mind right now. So yes, virtual currency will be the term we use as a result of it being part of the statute. I do know that one of the things on the docket that came up during the Management Council is some changes to statute with the Select Committee to clean up potentially things like the wording from that. And I think when we get into some of the complexities around that cascade of how the funds flow, we'll see some complexities there that may be triaged along the way. But for the time being, we're going to meet the statute where we're at and move forward from there.
Madam Chair. Thank you. I wanted this on the record so that it will be emphasized in the Select Committee meetings as very much a need for us to change, because again, it is not a virtual currency for various reasons. So thank you for that.
And I'll quickly note that Commissioner Naves has her hand up as well.
Thank you, Anthony. David, you are picking on something that has been a long conversation between industry and regulators overall around the use of the word virtual currency, including licenses that are required by different states, including New York, on what virtual means. The position has been made by different regulators and different thought leaders that anything that runs in a blockchain is a virtual asset in this, because this is a fiat-backed token is virtual currency. To your point, just because it's on a blockchain doesn't mean that it's the same thing. Several things run on blockchains and they're not the same, including to Kurt's earlier point about an algorithm stablecoin, which lacks stability and should be called something else, right? So you lump in virtual currency Bitcoin with fiat-backed stablecoins, which could not be more opposite to each other in principles of structure and how they operate and everything else. So this is something that has been discussed, and it was topic of several discussions and in the drafting of this proposed rule. And as Anthony mentioned, has been a recommendation that we have discussed in bringing to the Select Committee for consideration in adjusting state law to ensure that that term is properly defined in exceptions from the definition also made to include other terminology that is appropriate. So we will hope the select committee brings that, is brought to their attention, and that they think about that and get the support as needed to propose new legislation in the next session.
I wonder if we just couldn't recommend virtual asset in the rules, because virtual currency would be a rule, would be an asset. Or do we need to go to asset? Because that would allow, pursuant to this statute, when they changed it, then you wouldn't have to change the rules again.
So through the chair, Commissioner Meyer, my understanding is these rules are not going to make it through if we're out of compliance with.
I couldn't hear you.
Sorry. Commissioner Meyer, my understanding is these rules aren't going to make it through the promulgation process of Management Council if we're out of line with what's currently in statute, right? So in statute, not in the Stable Token Act, but within Title 34 on property, that's where the state defines digital assets, digital securities, and virtual currencies, specifically referencing stablecoins in that basket.
So currency is different than asset in the statute now?
Yes.
Okay.
Yeah, so it's a specific carve out. I think what you're hearing is, in my personal sentiment as well, I would hope that gets changed in the not so distant future, because we want to kind of move ourselves away from the connotation of a currency. So I think I would be supportive of Commissioner Pope's comments and Commissioner Nava's comments. And Commissioner Nava, once again, has a hand up, I think. If that's maybe
Yeah.
the same hand, maybe a different hand.
No, it's just a follow-up to Kurt. Anthony, thank you. Kurt, if you think of a virtual asset, a non-fungible token can be considered one. It's an asset and it's traded in exchanged in blockchains, So that doesn't solve what we need to do. To Anthony's point, we need to have more comprehensive review of these definitions to ensure that we are identifying different types of assets based on their properties and what they are used for and how they operate, and then define them that way. Otherwise, we're going to be putting a basket and throwing a bunch of stuff in it that there shouldn't be lumped up together. Yeah.
Okay.
Deb, I think.
Thank you, Commissioner. I just want to add to the chair that if you, and I believe Director Apollo did touch on it, that if you look at the rules, regulations, acts from any government regulatory body, you will see various terms and definitions of virtual currency. It might not be called virtual currency. You may see digital assets. You may see some promulgation of it. So from at least my perspective, it's not necessarily the words we choose, but how we define the words that I want to be most sensitive to. So the definition that we have currently on virtual currency may not be as up to date as it should be based on newer definitions that I observed that seems to be more in line with what the commission should be thinking of, more forward thinking, more long term. So I just wanted to flag that to the group. Thank you.
What I'm trying to do is trying to get it to this asset, to the statute, but not having to go back in and change it. So I'd say that WST as defined pursuant to WS 34. And then you don't define it in rules, there's the specific definition is in that you cite it, but you make it broad enough so as these other things come in, yeah, you don't have to change it. But if we can do it, we can just say it's just reference that section and just find out from our AG and what he thinks, whether or not we can make it that broad, or do we have to actually keep changing it every time the legislature does something different? So.
And Director, a couple of thoughts. My guess is if they go in and tweak that, they're probably going to be tweaking multiple things. And though I am
So you're going to have to go back.
probably, although I'm always on the lane of let's try to make these resilient, but my guess is we'll be opening these up regardless. But I do think maybe as much as we can today, leaving these as is, as opposed to crafting on the fly, and then recognizing that when we go to pass them, we could make some minor tweaks like that that aren't, I don't think that would be a substantive change, because we're still saying, you know, that's a change that I think maybe the AGs could look into, and we could tweak that when we actually go to pass them after public comment. Yeah.
Doctor, this is just discussion, so when Anthony gets in front of these guys,
Yeah.
he can kind of tell them what's on our mind.
Great.
Madam Chair,
Go ahead.
I had an idea, or I have an idea, and it may be, maybe not workable, but my thought is we also defined a consumer token within the, I believe it's the same statute that you're referencing here, earlier on in the statute. A consumer token may fit better what we're doing here, because we can use that definition here as opposed to the virtual currency definition. And no, has that,
Through the
go
chair,
ahead.
Commissioner Pope, to my knowledge, consumer token is not a term that we have in statute.
I'll get you some, because we defined a non-fungible token, which I think this partially fits that. And I believe we changed that within the following year to a consumer token or similar. So I'll take a moment to look that up while we discuss this further, and I can get back to you on it.
Just as a quick, through the chair, to put a bow on this, before you take that off, because I'm excited to find out. Are you referring to definitions that were part of the Wyoming Cryptographic Frontiers Act, which to my knowledge, okay. You know, that defined things like a public address and some other things that.
Right. No, this was 2019, maybe, that we went back and changed the original utility token definition, and I believe we added a consumer token definition to replace it. It's 6 years ago. I could be completely off base, but I am going to, like I said, I'll take a moment to look that up, and we can move on.
Seeing no other hands and hearing no other questions, I think we can move on. Back to Chapter 1, Section 4, Limited Delegation of Fiscal Authority. Again, we walked through this a bit more in detail last month. This is the method by which hopefully the agency and its resources can have its powers enumerated through this distribution of abilities from the commission. We did make some of the tweaks that were suggested by Commissioner Meyer as well as the governor at the last discussion, where for things that are as impactful as terms and conditions and privacy policy, those would require an initial approval by the commission before the agency was allowed to tweak anything. But then the agency would be able to, of its own volition, work on its own website, push out marketing materials, perform other public disclosures. There's substance in here about the ability to open up, different trust accounts, liquidity fund accounts, with administration accounts, and make sure that we have the money rails are open for the agency and its resources. So again, happy to answer any questions you have on this. There was, again, the tweaks were minor, particularly around the terms and conditions and privacy policy, because that was what was requested last time by the commission. So let me know if you have any thoughts or further questions, comments, concerns on the enumerated powers.
Any questions, concerns on Section 4? And I would note, I think this is fine, but a lot of these, particularly the first several, these are powers that any director of any agency would have. So I don't want to get too caught up in the details of those. And Mr. Kinney, correct me if I'm wrong, but a lot of these things as far as maintaining policies and processes and procedures and basically running the shop, those are powers you have anyway, so.
Well, through the chair, I mean, we've every policy, every change, every tweak we have approved through the commission. I think part of this is a function of myself being a one-man show for about a year
Right.
and needing to have some oversight, so it wasn't someone squirreled away in the Idleman just making all these changes. Now with a full team of executives that have demonstrated their expertise in a very short period of time they've been here, I think that there's more confidence in what we're doing. I think the media attention that we're getting on this is certainly part of that. And yeah, I would expect just to have the normal standard suite of abilities that any other director has.
Madam Chair?
Go ahead, Commissioner.
Okay, so House Bill 62 in 2019 defines a consumptive token as a circumstance when a token is exchangeable for or provided for the receipt of services, software, content, or real or tangible property, including rights of access to services, content, or real or tangible personal property. And that is also in, that was an amendment to the same chapter that you cite under R. And so, not being an attorney, and from an accountant's point of view, that may fit our definition better. But I would ask you to consider that because, again, we're not a currency.
So through the chair, I think if we were to take a straw poll here, I think everyone would hopefully agree that we're not a currency. Since we're backing it with US dollars and treasuries. Thank you for the clarification on consumptive. It's not rather than consumer. But I will say if I'm reading this correctly, the digital consumer asset that's defined as consumptive for consumptive purposes is 2 Romanets up from where virtual currency is defined, right? So again, if I'm a little, what I'm hearing is seems to be consensus that we understand that the statute's probably going to have a cleanup attempt. We're probably going to have to, if there is a larger cleanup attempt, it's going to impact other places of these rules than just this one definition, particularly around the cascade, which will be more cumbersome than this one word. I would just caution, we probably won't be able to issue this token if we don't have these rules passed. And I'm personally viewing changing statutory definitions that are already kind of well-defined in here is going to delay that if we can't get this through management council or other parties involved. Acknowledging, almost, not speaking for everybody, almost uniformly, we're all talking about a recognition that we're not a currency and this needs to change. But again, we are basing our rules on the statute as written.
Which we must, even if we, yes. And again, that may get changed or it may not.
Any other thoughts?
Madam Chair, I'm fine with it. Again, I'm on the record as believing this is a consumptive token as opposed to a virtual currency. So that's just my thought on it. I will vote in general to approve these so that we can move forward. Just want a part of the record.
Thank you, Commissioner. And again, non-substantive, minor tweaks can be made to these after the comment period. So we have a little bit more time to think about it.
Thank you, Madam Chairman. Okay, so hearing no other questions, I'd like to move on to chapter 2, also quickly acknowledging that we're at about 50% of the way there time-wise, and certainly don't need to take all 3 hours, but just keep an eye on the clock. So this chapter is on the issuance of the stable token. So again, this is how dollars come in to the agency and Wyoming stable tokens go out. There really weren't many changes to this section. So not really too much from my end to cover off on, other than using the formal term issue or issued in several places that we had it not capitalized previously, incorporating the term whist in circulation in several places. Beyond that, this is pretty much the same as it was last time. So everyone a moment to kind of just take a look at that and let me know if you have any other feedback.
Director, why is issue capitalized?
Because that is a proper term in chapter 1, section 3, where issue, issued, issuance, redemption, redeem, those are all proper terms that are defined. So for example,
Anthony.
issue,
Anthony.
through the chair, Commissioner Navas.
Yeah, thank you. Christy, defining issuance and redemption is quite possibly one of the most critical pieces of this thing. Because again, this is at the point in time where the commission is going to be taking fiat currency from the holder and giving it back. So there's got to be really clear definitions around these terms to ensure that we're not only accounting for that obligation when it occurs, but also being able to record it for Joe's and auditors' perspective, everything in the correct time.
Go ahead.
Are there any other questions on chapter 2? One last thing I'll just repeat that on the way out is, again, we're only really counting Wyoming stable tokens issued on the chains that we have approved. If people start trying to migrate or wrapping Wyoming stable tokens to move them to other chains, those will not be considered whist in circulation, so we will not count those in our metrics. Moving on to chapter 3, this is reserve asset management. We'll probably spend a few minutes here again on this concept of the cascade and just kind of walk through that. So again, I'm just picking up where I spoke a little earlier about the trust account. Again, this is the section in which we focus a lot on the 3 types of account. We have the trust account. That is the account that is one-to-one backed with the token. So 100 million stable tokens outstanding, 100 million in cash and treasuries in that trust account. Interest is generated off of the underlying securities. Those get swept at some recurring frequency into the liquidity fund account. That's where we start stockpiling the funds up to that 102% buffer, 2% buffer. Once we get past that 2% buffer, then we have I believe we couch this in as as part of the recurring meetings, the commission can opt to reserve more than 2%. That's conversations come up a couple of times. So we try to hit those numbers, whether it's 2% or more, not less. And then if the amount of reserves in liquidity fund account exceeds that 2% or amount approved by the commission, the director or staff is authorized to transfer any and all excess funds to the Wyoming stable token administration account. And those will be typically, we assume, dollars that fund the agency, right? Those are the dollars that'll go back to pay the general fund obligation that we have. That'll go to pay payroll and salaries and benefits. That'll go to pay for everything that this organization does, hopefully in the future. That is certainly the goal here. And then after, again, so in the event that we have those dollars coming into the agency, during the recurring monthly meetings, the commissioners can take a vote as to how much should be transferred or perhaps kept in the administration account for kind of R&D purposes. We do have that called out in statute, versus how much will get swept into the school foundation fund, which is a kind of ultimate resting place of the dollars generated by this program. Beyond that, in this section, we also talk about the commission collaborating with the treasurer's office to develop a investment policy statement. And again, we're already making some great progress there in that direction. And then I think that's probably about all I wanted to cover, except this last note on page 10, reserve attestation audit. There were a couple permutations of this document where we looked to put in a audit and attestation section to these rules. As we got into the thick of it, the concern was accounting and audit for reserves is going to be one thing. Accounting and audit of the tokens in circulation will be another thing. And then the two need to meet in the middle for the full reconciliation. So what we're thinking of now is we'd rather have a policy governing that attestation process in the near term, knowing full well that it may take time to get our tech partners spun up for, we would love to do real-time attestation, but that may take 3 months to get to. So I'd be loath to put in rules, we're going to do real-time attestation, then spend the first few months doing, weekly reports. So the goal, and of course, then we need to, if we're doing the audit and attestation rules and reserves, it's going to rely in some capacity on tokens, which are going to be a different rule set, and vice versa. So the thought is we'd have a policy that brings the two of these together once the reserves management and the token rule sets are both complete. Then we could have a tertiary policy that marries them up. If that becomes a unified rule set later, fantastic. But we've walked through this several times as a team. We've drafted the language, we've put it in, we've taken it back out. And this is where we ended up after a couple of rounds of back and forth on that, with the position that, again, a policy would be the strongest way to introduce this and then roll it into rules at a later time.
Can I ask for a little more explanation on the accumulation of reserves over 2% or such amount approved by the commission?
Sure.
So are we allowed, because I think we're going to need a cushion in there to plan for bigger deposits. So this will allow us to do that. Is that what that's attempting?
Through the chair, Commissioner Wallace, that's absolutely correct. I believe it's something that you and the governor brought up several months back, not too long into my tenure, the need for potentially additional buffer over the 102%. And that's what we're trying to accomplish here, right? There's nothing stopping the commission from voting and saying, well, we want to reserve 110%. Now, every time that number goes up, less funds get returned to the agency, and less funds then make it to the school foundation fund. But that's going to be all part of the metrics and levers we could pull along the way. Things will change over time, but it's certainly in the commission's purview to increase that number if need be, especially if we're detecting times of volatility. We may, and then Joe will tell you this himself, Joe not to put words in your mouth, but we've had conversations between the two of us. He also has created scenarios where we're reserving more than 102%. So, we may come to the commission ourselves and say, the Fed's finally going to start cutting rates. Let's boost these reserves while we can. Or still have 4.25, 4.5 before we get down to 2 or 1 or 0 again. So,
But that would not allow us to take it below the 2%, though.
so through the chair, that is correct. The 2% is a floor through statute.
That's statute, so that's minimum. Okay, thank you.
Any other questions? Okay. With no other questions, I will move on to our fourth and final chapter here. This is the redemption of the stable token. Again, this is just the reverse polarity of the issuance. This is someone who holds Wyoming stable tokens, comes back to the agency, says, hey, I've got whist, I want my dollars back. How do we reverse this transaction? The main piece here that we've updated since the last go-around does, again, coordinate with Commissioner Navez's point around the unavailability. That's the break the glass scenario in section 3B and 3C. That's when we say there's only in these very specific circumstances can a token holder come back directly to the commission to seek redemption of Wyoming stable tokens for a notional amount of US dollars. And the rest of it's pretty straightforward. Section 4 covers off on calculating the list value at redemption. Again, that ties back to a very specific paragraph of our statute, which says, we don't back the Wyoming staple token with the full faith and credit of the state. If for whatever reason the buffers don't work, the one-to-one doesn't work, and we do depeg, and someone tries to redeem, and the notional value of a Wyoming staple token is less than $1, we're not going to put, top it up to 10 with 10 cents. It will be 90 cents. That's the 4031-107 reference. Any questions on Chapter 4? And through the chair, I would again offer an opportunity for Ms. Brooks to speak on anything that I missed or anything she wanted to highlight herself. A tremendous amount of work from her side went on this. I want to respect and reflect that and give her an opportunity to speak to any of this.
Thank you, Director. As Director pointed out, a lot of work was involved, not only by me, but by others as well, to get to this point before the commission with the recommendations that the director will make. Of course, I've spoken with several of the commissioners on the panel about this, so I feel very confident in this work and this body of work that has been created and presented to the commission staff for your consideration. Thank you.
Thank you, Deb. So through the chair, if there are no questions or comments on any of the content in the rules as drafted, on going back to the memo, you would have the director's recommendation to authorize the executive director to pursue regular rulemaking for reserves management as drafted or as amended, inclusive of completion of any forms required by agencies involved in rulemaking, including but not limited to the Attorney General's office, Secretary of State's office, Governor's office, and Management Council. And that's the wording we've used in the past for procurement and other rules as well.
Madam Chair? So moved.
Moved by Commissioner Pope, seconded by the Commissioner Meyer / Treasurer. Any further discussion? And then, like I said, knowing that these go out to comment for a minimum of 45 days, and they'll come back to this commission where we could make minor tweaks, but not massive substantive changes before we approve the final version. Anything to add to that we should expect?
Madam Chairman, no. I mean, candidly, it would be my first time going through the formal, regular process this go around, but we got the oversight of the AG, and I'm certainly familiar with the training materials that have been provided, the handbook, about the de minimis changes that can be made. This is, I will quickly just note, if we're able to get this promulgated before federal law goes through, this will be the first rule set in the United States pertaining to reserves management. Right? New York DFS has guidance. I respect that, and the federal government is working, bicamerally to get the Stable Act and the Genius Act through. But this will be a first if we are expedient about this.
Unless some municipality that we do not know of at this point issues or promulgates rules
So point being,
in the
Madam-
next 3 months. I've heard Shoshone
Not-
was thinking about it.
Not a stable coin. So Miami had Miami coin, New York had New York coin, both, I think Miami coin was a function of the pandemic and a lot of venture capitalists moving to Florida from California and bringing the crypto enthusiasm with them. Just to go back to the comment that I made, it's to just, once again, give the team and all of our supporters my thanks, but also to say, with the public comment period, procurement rules and public records requests are one thing. This may have a lot more attention on it. So, we've had to really kind of steel man this as much as we can. And to the extent that there's comments, we'll try to keep them, de minimis. But we'll see what comes back. I have a lot of eyes on this.
Yeah. And then, of course, the commission will have a chance to review everything that comes in as well.
Madam Chair,
ahead.
one comment before we vote. I was just doing a legislative history on 3429-101, and the final version of it I am more comfortable with, which includes Romanet 4, item B in 101, that says not recognized as legal tender by the United States government. And then you look at 102, combine it with the definition of virtual currency there. I'm a lot more comfortable now.
You can make anything mean anything if you put it in statute.
You bet.
Right. Any other commentary before we go to a vote? I would echo the director's comments that the work on this has obviously been substantial, and I appreciate that. Okay, all those in favor, say aye.
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 All right.
Opposed? All right, motion carries.
Thank you, Madam Chairman. Thank you to the commissioners. Again, just keeping an eye on the clock, this next memo for token testing will be a bit more expedient. So this is, all good? Oh. Yeah. So what we're trying to do here is again communicate some of the more technical elements of what we're doing, generally speaking, and then make sure we have the green light from the commission to pursue this pilot program I had mentioned a little earlier. So goal for this is to kind of socialize the plan for what we call user acceptance testing and end-to-end test scenarios to ensure that the functionality we desire to have in the Wyoming stable token is available and working as intended. Also, we want to create a pilot program in order to expand end user testing, engage the Wyoming public and domiciled companies, and generate public confidence in the initiative. So from the background perspective, we cover off on the fact that the commission has already approved the executive director and CISO to issue unbacked, i.e. not reserved, test tokens on blockchain testnets. We then went ahead and did this. So on March 26th, following the engagement of Layer Zero Labs as our first formal partner in the token development kind of build out here, they worked with us to deploy test Wyoming stable tokens, which I've now referred to as TWIST, on 7 interoperable candidate blockchain testnets. Those again being Ethereum, Avalanche, Solana, Arbitrum, Base, Optimism, and Polygon. Following the testnet launch, the commission resources, so the agency team, has begun the testing of UAT and end-to-end already. And this is a very critical thing for us to do because we got to make sure everything's working under the hood. So for user acceptance testing, it involves real users, but in a production environment, right? So the key objectives here be to verify that we're meeting our requirements, ensuring that the front end of the system is usable. So we say ensure the system is user-friendly and performs as expected. Make sure everyone, if it's a website or a platform, everyone knows what the buttons do, where they're going. And then, of course, do some bug squashing before we launch.
Mr. Chairman, or Madam Chairman, I've got a question that the people in the know seems obvious, but evidently I'm not in the know. You've got these things in parentheses here: Sepolia, Fuji, DevNet, Amoy. What are those? What do they designate?
Madam Chairman, Commissioner Meyer, those are the specific test nets themselves.
That's a test net what?
It's a test net. So Ethereum is the blockchain.
Right.
And if you were to use Ethereum in production, right, I wanted to send you 1 Ether, we'd use it's called mainnet Ethereum. That's the production version of it. That's the version that has value. Money's being transferred. On a test net, there's no monetary value going back and forth.
Right.
Right, so this is simply the name of the test nets we've launched on, because some of these chains have multiple test nets as well. So Polygon, we're on one called Amoy, that's with their proof of stake system. They've got a separate one for.
And they're supposed to mimic the real live
Exactly,
internet and everything else, all the different steps and pathways.
exactly.
Okay, so that's the test net.
Yep.
All right, okay.
Yep,
Yeah,
and
thank you.
thank you for the opportunity to clarify that. It's on our site when we have documents and FAQs about all of that, where this is all spelled out. But yeah, should have been a little bit more overt about that in this one. So moving over back to page 2, there's, user acceptance testing. We give an example use case of what the function is, what we're trying to do, the conditions, the steps, and the results that we would expect. Then you record what happens. So while not a printout, well, I don't know if we printed it, but in the commissioner folder on Drive, if you wanted to see some of these, we've got our testing scripts uploaded for the commissioners to take a look at as well, to get just an idea of what it is we're doing and what we're testing. Flipping over to page 3, this is end-to-end testing. So again, we've got this kind of process flow view in this document. Goal here is to start at the start, end at the end, right? Make sure every step in sequence is working as intended. You're not breaking the sequence. You can't come in the middle of it and change something. Everything's working from front to back as desired.
So a question I got, I heard one of the weak spots in some of this, I guess this whole area is the bridging, where you have buffers and they get stuck there because you got too much volume, and that's a spot where people attack it. So did we try a volume thing here to where we got it to a situation where it actually overworked the buffer? So we know that was, and I think a lot of those things have been addressed, and maybe that's not a problem anymore in the universe, but maybe a little conversation on what that
Sure.
came out to show.
So through the chair, Commissioner Meyer, I will turn it over to our CISO, Keith Lawhorn, in just a second. Generally speaking, we just want to flood these networks. It's something we could potentially look at doing intentionally ourselves through some of, bringing other users on board and trying to all do the same transactions at the exact same time. Throughput's going to differ per chain, but Keith, I will let you opine on whether, I don't know if during, and again, pardon the vernacular, Commissioner Meyer, during fuzzing testing or some of those other protocols, one of the things that those tests accomplish is just throwing a bunch of traffic, like a DDoS at a network or page, or the blockchain equivalent of that, but I will let the expert speak to it.
As our testing matures, we will be able to create repeatable tests using a smart contract that will make the calls automatically, so that you can programmatically test stuff like load. And those tests will follow the user acceptance testing. We should have a written test script for each scenario that's implemented.
So I guess what's the history in the real world, in the payment universe? I think it was I won't mention the name, but one of these blockchains here had a problem with just not being able to handle it, and when they got into a buffer, it was attacked. And so regular, I guess, flow was fine, no security problems, but when they got too much volume, then they had basically a hole in the wall.
Yeah. So through the chair, Commissioner Meyer, just a couple of things I'll rattle off. One is, we have in our blockchain selection exercise, which we'll be talking about and revisiting briefly, some of the criteria that were in there were really focused on throughput to, accommodate and hopefully avoid some of these issues. I'll also add that there are scaling mechanisms built into most blockchains. When the transactions, start lining up, it becomes more expensive to do. So you have these kind of levers to pull of, if the transactions are going through because there's too many of them, make them more expensive, there will be less of them, that kind of thing, right? So those are kind of built into the network. And then one other thing I would say about layer zero, we didn't necessarily have interoperability between chains as like a key criteria. We just were looking for, let's issue on one token to start. They came along with what they refer to as the omni-chain fungible token standard, which is interoperable kind of out the box. And they've secured, I think, 70% of cross-chain messages, something like that, and billions and billions and billions of dollars without being compromised. So that, that's what gives us a lot of confidence. I'm not going to speak for the evaluation committee, but I'd assume that's, a lot of the points were resultant from that situation. And Keith, again, if you've got any other color to add here, or if I misstated anything, please do feel free to correct the record.
I would just say that usually like a race condition that might be caused by congestion would be something more like a complex contract for trading or automated liquidity, stuff like that can have congestion-based problems more so than a token, transferred.
Any other questions on the end-to-end testing?
Anthony?
Thank you.
Yeah. Am I seeing correctly, and this may address some of Kurt's questions. On page 3 of the user acceptance testing, there's a line for bridging. Am I looking this correctly?
Yes, we are going to do bridging scenarios.
Thank you, Keith. So Kurt, this may address some of your concerns. It's a line for testing. But maybe Keith, you can just provide a follow-up to the commission on this specific topic to address some of Commissioner Meyer's concerns.
Yeah, so in the user acceptance testing, you'll see just a simple set of tests for one bridging transaction. What we will do is take the end-to-end testing and bridge from multiple scenarios. We'll bridge from each destination blockchain to each from each source blockchain. And we will try scenarios that we expect to fail, scenarios that should be successful, in any edge cases. So that's the same for each test you'll find in the UAT.
Thank you, Keith.
So if there's no more questions, we can move on. Integration testing, just a quick note at the bottom of the page here. This is going to be something we kind of punt on until all the vendors get on board. So integration testing means when all the vendors are on board, we put them all together, we glue the parts together, and then we test the full front-to-back flow, even beyond just the confines of a smart contract or the token. We test the whole process together. Okay. Last page, public alpha and pilot. So again, we want to test the platform as much as possible. And to that extent, it should, expand outside of just the commission, just the agency. So we did set up a public alpha program. We'd socialized, I believe, at the last meeting of the commission. So we are registering Wyoming residents and domiciled entities to participate in public testnet end user testing. Again, we've got links to the form, which is available on the commission's website. And we just go and collect contact info and digital wallet information so we know which wallet is yours. If we want to start sending tokens around, we could do so. And I will reinforce here, with the layer 0 and where they deployed for us, we've already got Wyoming stable tokens moving across testnets, different blockchain testnets right out of the box. So we've already been able to start testing internally. Second piece here is our desire to facilitate a pilot program for test Wyoming stable tokens with a limited number of Wyoming domiciled entities that operate existing blockchain-enabled platforms. So it's one thing to do the testing that Keith is talking about where we're sending tokens back and forth, we're sending different blockchains, we're testing different functions. That's all great and it's all extremely necessary. But one of the things that I think we have a really incredible opportunity to show here is partnering up with organizations, entities domiciled in the state of Wyoming that have platforms that are blockchain enabled, that are already talking about using Wyoming stable tokens or integrating or embedding them in their platform. To give you an example, last week, or perhaps 2 weeks ago at this point, a team called Cattle Proof, which is a Wyoming domiciled entity that does, it's also a USDA verified provider of information pertaining to cattle. They put all of their verification data for livestock, feed, farm equipment, they put it all on chain. They're able to actually show that what they sell at the end of the day is worth more because you have this transparent asset trace of where, you know, this particular steer has been and their vaccinations and their feedlots and all of that kind of stuff. They were invited to testify in front of the House Agriculture Committee's subcommittee in DC on April 9th. And the subcommittee is on rural markets, commodities, and digital assets. So one of the members of the Cattle Proof team, Mark Tague, was able to provide his testimony, which he mentioned specifically using Wyoming stable tokens as part of their platform, which is again they now use it to move data around, but they want that data to be in transit simultaneously with value. So when you sell a steer, the dollars and the data all move together. And this is what I'm talking about in terms of pilot programs where we can start looking into companies that are our neighbors across any number of use cases, whether it's cattle, whether it's contracts, whether it's, you know, what have you. If there are things that could use Wyoming stable tokens to make things that give us a headache nowadays more efficient, more streamlined, faster, we should be trying to sign those cases up. My point here is not that we can, you know, join these teams and start building on their behalf. We don't have the resources, time, nor budget for that. But if these are people already in the state of Wyoming who already have interest in building alongside us, I would make the argument we should get them registered a little earlier. So the recommendation that I've put here for the public alpha and pilot is to authorize the executive director and chief information security officer to distribute test Wyoming stable tokens to Wyoming residents and domiciled entities who register through the aforementioned alpha testing form and oversee the public testing of all user acceptance testing and end-to-end protocols thereof. And the second authorization would be to develop and deploy a test WIST pilot program, onboard Wyoming domiciled entities as participants as appropriate, inclusive of digital wallet configuration distribution of WIST, and oversee the integration of test WIST into existing blockchain-enabled platforms. There should be a period at the end of that. One more thing I'll quickly say that I skipped over is we expect that if we're going to be onboarding anybody, it will have the same composition of the SMAs we brought on, where they'll have to sign a code of conduct to say there's no financial benefit. These tokens have no financial benefit. This is just a test integration to see if a stable coin can fit into this prospective use case. It seems to be an important note. So.
Director, what do you expect the volume you're going to be able to accommodate as far as folks who are eager to test? Or do you anticipate that to be robust?
Madam Chairman, I don't know how many signups we have already. I think it's close to 24. We've already got close to 24 people signed up as just individuals. And then in terms of pilots, I could think maybe you've got bandwidth for 3 because that'll be more hands-on. I'll defer to Keith quickly through the chair, just to give an idea of, you know, we have X number of testing parameters for the user acceptance testing. You know, are we assigning those 1 per person? Is it 1 per person per chain? You know, I don't know how many people we need if we want to be comprehensive versus very comprehensive. So I'll turn it over to you for some context through Madam Chairman.
What I'm envisioning is giving some roles out, so assigning people roles and explaining how they'll participate, giving them the test scripts, and potentially creating a video on the wallet setup and configuration. And then the balance of the users, we can issue tokens directly to them and have wallets set up for them to transfer to and from. So then we might have more sophisticated roles for some of our subject matter experts or some of the commission subject matter experts to help us conduct more thorough tests or some of the roles for compliance and supply management.
Madam Chair. Director Apollo, thank you for all of this. I'm happy to move items 1 and 2 concurrently in your director's recommendation. My only question is, this seems to be within your operational purview to actually test the token. Do we need commission action on this?
Through the chair, Commissioner Pope, this goes back to the part of the conversation we had earlier during the discussion of the rules and the authority delegated. To be quite candid, I don't know sometimes what has been delegated in terms of responsibilities or what are the de facto responsibilities. To my knowledge, that's not really written down anywhere. And also the fact that we are doing so much net new work. I don't know of any other agency that's testing tokens and figuring out whether or not that's their purview or the board they report to needs to do it. Just being candid.
Yeah, great question, Commissioner. I don't think we need commission action, but it certainly provides some guidance and comfort for the director and staff to say, you've been informed of what I'm doing and had the opportunity to tell me to go a different way, so.
Okay, then with that information on hand, and in order to provide comfort, then I am happy to move items 1 and 2 concurrently.
Is there a second? Okay. Any further discussion regarding the token testing memo and the director's recommendation that they move forward with this plan? Go ahead,
I just
Commissioner.
got just one quick question, because I guess I thought there was already some testing going on. Was that just the registration process, or is there some basic testing that has occurred?
So through the chair, Commissioner Wallace, it's 3 flavors. Testing that's been done to date has been done by the team. So the agency, right? We're the ones who have access to the Wyoming stable tokens on these 7 different test nets. We're working with layer 0. We're sending things around. We're, Keith's looking at some of the functions and testing those out. So that's all been internal. While we've been doing that testing, we've had on our website a portal for individuals in Wyoming, and again, registered Wyoming entities, to say, give us your contact info and your wallet address and let us know what you want to test. Because when we move off of kind of this in-house testing, we need to bring more people in, as Keith just mentioned. We need different people assigned different responsibilities, different browsers. You need to put all these variables in there. So we're signing those people up now for more testing at scale beyond what just the team internally is doing now. And then with the pilot program, part of that is more testing and not just, again, peer-to-peer transfers, but how does it integrate into an existing system? But also, again, candidly, we certainly get asked a lot, why does Wyoming need a stable token? And if we're able to point to local users who already have blockchain-enabled platforms who've built it because of the legislative environment in the state of Wyoming, and can say, I could sell a cow for 50% more because all of my data is on chain, and now instead of having to worry about 2 weeks of settlement time, I can have my dollars in 30 seconds. That's the stories we should be telling, because that's going to be more impactful than just it's good for the dollar, it's good for the state, right? These are real people with real needs who we can help. So 3 flavors.
In other words, it's to see if even people like you and me could do.
That's my question. I just didn't know.
Any other further questions, discussion? All right, all those in favor, say aye.
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 Opposed? Opposed? All right, motion carries.
Thank you, Madam Chairman. The last topic for the day before we start winding down is an update on the blockchain selection scoring. So again, this is, just to quickly recap, this is part of a rolling process, right? So we did the quarterly, we call it the Q4 review last year, October, November, December. the Commission's approved rules do rolling qualifications. Those rules are still in flight. That's the public comment that's currently ongoing. But we have opted to, without the need for a mandate, just go ahead and keep the process rolling anyway. So again, thinking about this as something that happens quarterly, month one would have been last month. That's where we updated the criteria. And in this memo, we added just a kind of a refresh of what we did update for this selection process. So on-chain analytics and vendor support, which reflects the fact that we're bringing on, we're actually engaging with these parties, and additional benefits, you know, the Wyoming domiciled foundation being more specific about what that is, emerging market trends, to see if, you know, this chain or whatever chain is working on AI, decentralized physical infrastructure, et cetera. So we added all those. And then so that was month one, and then month two, which we're kind of closing out now, has been reaching out to these first-party resources aligned with any given chains. That could be developers, founders, foundations, for data. And we've got some, we're referring to as preliminary results of that exercise. So that inbound was due on April 15th, so just the beginning of this week. And we're, you know, obviously want to give some time for back and forth with these providers. And the goal would be to kind of have formal scores available at the May meeting and then keep this process rolling. So in June, we're back to reviewing criteria. But what we can go through is on page 3, we got the assessment here. What we did was review everything from the top. So even our 9 candidate blockchains that we had from the first go round of this, we reassessed their ability to meet all of the binary criteria because we updated those to include vendor support for the teams we've chosen rather than, you know, a smattering of 2 of these 4, right? So we found that the 7 candidate blockchains that currently host testnet Wyoming stable tokens meet all those new binaries. The 2 candidate blockchains that do not currently host testnet Wyoming stable tokens may be partially supported or are expected to be fully supported by anticipated vendors within the confines of our biennium, but they are not today. So we wanted to call that out. And then we also looked at all the blockchains we had in scope last time for the exercise, as well as new ones that signed up. So if you look at the last time we did the exercise, there was 28 chains in total. 9 of them were candidate blockchains. That leaves you with 19. Of those 19, 14 did not meet the binary criteria. 5 passed but did not score high enough, and then 1 was disqualified of those 5. And then we got 4 new blockchains applied for assessment through the request for information and consideration form hosted on our website that we set up. So all in all, 22 different chains were reevaluated. And there's a piece down here about the outreach as well, because there was an ask that we make sure that we're getting read receipts and all of that. So that's all incorporated here. And then we mentioned that submissions were received from 10 chains. 6 were ones that we have evaluated previously. 4 were the new ones that I just mentioned. And again, those came in earlier this week. So we've looked at those submissions, and what we found at this time is that only, again, this preliminary state, I will be specific, preliminary, only 2 of the networks pass the binary criteria, which again has been updated to include working with the vendors that we're engaging specifically. And again, the chains we already have in scope are well covered. So that's a consideration, and one of those may be disqualified due to additional concerns pertaining to its technical robustness. They had a smart contract issue, I understand, to be fairly recently, so that may change things. All that to say is we're still rolling this forward. Sorry, we're still doing the back and forth with the teams. This feedback will be provided to them this afternoon. You as the commissioners already have our scoring assessment in the drive folder. Like we did last time, we will push all of this research and assessment public, but we'll do that after we speak with the teams directly and make sure that if they've got one position and we've got a different one, we have that conversation to make sure we arrive at a score for each chain that is appropriate and reflective of their capabilities.
Madam Chairman, I
Go
got a
ahead.
question. You know, we're doing this testing stuff of these different blockchains here. So do we get that criteria during this test period here as to, the speed, the accuracy, everything that we're evaluating, onboarding, different blockchains? Do we get that data in this test, exercise?
So through the chair, Commissioner Meyer, that's an excellent question. I might take it in two directions. So if the question is, are we incorporating our own testing findings that we just talked about with the candidate blockchains to the blockchain selection exercise? We certainly can. The difference with that would be we're on test nets,
Right.
right? So while those are meant to mimic the real deal, fees are typically cheaper, transactions can be faster, things can get a lot more cumbersome when you hit the mainnet. So the goal of the blockchain selection exercise has always been and will always continue to be, we're looking to use numbers associated with existing and demonstrable technology that is deployed to mainnet. So while we certainly can't come up with our own metrics, and we should and we will, what we're talking about for the blockchain selection piece is making sure that this is, tech at scale.
Let me clarify where we're getting this headline data from, or whatever it is. So is that derived from like a broker that actually runs all these different blockchains across it, and they have a performance record that's documented? And so then that's essentially, I don't know whether it's proprietary or public information from the broker or not, but I'm just trying to get a totally non-subjective metric that we could say, okay, this is how all these speeds work, in the test net. But if we don't have that better data, essentially, that's in the real world that we can rely on with different brokers or whatever we're running through.
So through the chair, Commissioner Meyer, another great question. I would just simply swap out the term broker and use the term analytics platform, because all this data, this on-chain data, is open source. It's available to anyone. So all of these different analytics firms, whether it's Dune, Masari, we use one called Artemis, rwa.xyz. These are all public, free, comprehensive, objective, listed and linked on our websites. And we're consistent about how we deploy those metrics on those pages to what we're looking at. So we're comparing as close as we can, apples to apples. And again, these blockchains can work different ways. So, there is some considerations there. And also we need to make sure that the analytics platforms are looking comprehensively at all the data that's being generated, right? So, for example, when we did this exercise the first time last November, the Avalanche blockchain, we said, okay, you guys have X number of users on your C chain. That's the main kind of throughput chain of Avalanche. Avalanche came back and said, well, that's what's on C chain, but we also have this concept of used to be subnets, now they call everything layer ones, where, okay, well, you need to look at, for our daily active users, you need to look at the totality of all of these subnets and the C chain put together. Okay, so that made sense to us. We verified that, we checked it, and that number got boosted. On the other hand, they said, we also have this many, people playing this game called Off the Grid that leverages the Avalanche infrastructure, but it's on testnet. We've got 1 million users over here. Is that considered? And we had to say no, because it's not on mainnet, right? I mean, they still scored well, still one of our candidate chains, but that's kind of where those lines get drawn. And that's an example very concretely of how we need to be thorough in how we're assessing this and accumulating all this data. It also goes back to your point previously about verifying with the first party sources, which is at this point our starting point for this. We're going to them first, and then we're verifying.
Have we determined who are, I guess, we're going to have an analytics vendor or whatever, or somebody that watches over what's going on with our token? Have we determined who that's going to be yet?
So through the chair, Commissioner Meyer, I would offer that analytics is a key part of a bunch of the different platforms we're looking to bring on. So with Chainalysis was our highest scoring respondent in the on-chain analytics
Yeah.
RFP. So that's certainly analytics out the box.
All right.
They integrate with Fireblocks, which is the highest scoring infrastructure provider that we interviewed. They've got their own dashboards. Inca Digital has the ability to build their own dashboards and pull in all this data. And again, we can also just use what's open source already, and we have been, and monitor our own smart contracts. So I think for us, it'll be less about getting the information and more about how to present a large amount of information coming from multiple sources in a comprehensive but streamlined way for ourselves, the team, and of course, the commission.
Yeah, okay, thank you.
Back to the memo, just to round this out, in terms of next steps, we're not asking for any action from the commission today. All to say is this is an update at a high level of the number of respondents we have, who's moved along in the process, how we're continuing to communicate with these first-party resources and rely on them for their data, but verify it when we get it in. And the goal for us is to have scores ready at the meeting in May of all of these, following, again, the back and forth with the teams. And then that back and forth with the teams, I think, will give us a good idea of whether we need a parallel process for UTXO-based blockchains. I'm going to hand wave a bit of the technicals here. A lot of the chains that we're on would be considered account-based, just the way the blockchains work. UTXO stands for unspent transactions. It's how Bitcoin and its infrastructure works, and several other chains that are interested in joining our process here are also UTXO based. If we feel that they are being left out in the cold because one technology stack supports account-based models, another technology stack supports UTXO-based models, we should have a conversation with some of those teams and present those findings to the commission in May as well about how we roll that forward. Because again, we do have a remit from the legislature to be multi-chain and tech agnostic. So I don't want to say we're going to go over here on this side of the playground and then leave everybody else on the other side. We have a mandate to be magnanimous here. Any other questions on that update?
Okay, next steps.
Okay, we will start winding down, and thank you, Madam Chairman. So in terms of next steps, again, I think you've heard a couple things from us today. Alpha testing results, vendor contracts certainly on the docket, but we've talked along the way about the blockchain selection results. That'll be there. We talked about the yield memo earlier, and perhaps, maybe a little soon, but if we're giving ourselves an extra 2 weeks before the next session, we might even have someone able to demonstrate one of those pilots that we're talking about, which would be great. In terms of upcoming meetings and events, as we talked about before, the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology will take place in Jackson, May 14th and 15th. I will be there in person for both days, because it is assumed that we're going to have a lot to talk about, possibly even an early attempt or discussion around some of the statute that we need to scrutinize along the way. So I will come prepared with that. Simultaneously, Consensus 2025, which is one of, if not the largest blockchain events in the world, will be taking place in Toronto, Canada. They've invited Joe to go speak, so he'll be making the trip up north along with Keith. And then we had a to be confirmed monthly meeting on May 15th. That's the one that we're going to move to May 30th. Beyond that, I will also be attending the Avalanche Summit in London. I will be speaking there in the UK. And I will also be speaking at ETH Dublin directly following May 23rd to 25th. So again, these are both events organized by communities that represent two of the large cap candidate blockchains we have. So this is an opportunity to meet with kind of key executives, community members who want to use a Wyoming stable token on those platforms, developers who want to build applications that are going to use Wyoming stable tokens. So I'm really excited to meet with a lot of people who could be, net end users of WIST at the end of the day. And then quickly, public comment will be open today. Duration will be limited to 3 minutes per speaking party or one question from an online participant. Speakers will be asked to provide their first name, last name, and affiliation for the public record per WS 16-4-403B, and decorum will be governed by the rules and standards of Management Council Policy 18-03, Wyoming Statute 16-4-406. So, Madam Chairman, I'm happy to answer any questions on next steps or upcoming events. But beyond that, we would be moving on to public comment if there is any.
Question, Commissioner?
No, but, you know, I'm always trying to figure out how I can invest these stable tokens and make more money out of them. I think maybe what we might look at is basically a token that the state would buy, or more specifically, the Treasurer's Office would buy for an investment. But it wouldn't be for like an overnight investment. It would be for a period of, at least 8 years. So what we could do there in that situation is that over that time period, we could essentially guarantee, say that the roughly 4% or 3.5% that you're thinking you're going to get on short-term investments, but investment in a manner that would be more like a 9 or 10% return. And then essentially no one gets harmed as far as the school or the general fund where that money would be going into. And then the excess we could basically distribute to the Stable Token Commission. So it's a way to use the same amount, but what we have to do is basically kind of a different class of stable token that only the State Treasurer's Office could invest, and have the same backing, that it would be 100%, but the interest, we'd be able to get more off of it because we'd make a contract with the commission that we would keep that token for 8 years. So that's one way that we can actually add a time value to it and get more than we're getting out of it, and be able to substantially make a contribution to the token without anybody else getting harmed.
Through the chair, that sounds great. I'm happy to sit down with you and Joe. I mentioned to Joe that we had spoke earlier in the week. Happy to sit down and kind of map this all out with you.
It would take statutory change that this would be a non-public token, just issued to the State Treasurer's Office for the purpose of investing, and over that time period, we keep the same return back to the education system, but anything over that would be put back into basically the Stable Token Commission.
Through the chair, Commissioner Meyer, that sounds great. I think the timing for us to have this discussion is right, because if the expectation is, we're going to have these meetings in Jackson, the select committee is going to kick off. If this is public news that was said to me at the Joint Appropriations Committee, there are people, on JAC who are very interested in, tokens that are backed by gold or other commodities, right? So I have to, and this is an assumption, but I'm assuming if we're going to start opening up different parts of the act or creating parallel acts, everything's on the table. So if you and I have a chance to sit down with Joe and perhaps Norm when he's back, map this all out, happy to do so. And we could even have this ready for a May discussion.
Okay.
Madam Chair. Mr. Treasurer, one of the things that I am concerned about is our ability to maintain the 2% excess reserves. So my question would be whether there is a way for the Treasurer's Office, possibly in conjunction with some additional legislation, to pledge those investments to the excess reserves only, and in order to satisfy that without sacrificing yield to the Treasurer's Office. And I know right now there is a prohibition within the statute of the state of Wyoming being obligated, but we're going to have to deal with this issue at some point, especially if the stable token cycles up as quickly as we think it may.
Yeah. I see no problem with earmarking that for excess reserves. Thank you. And then after that would spin into, you know, I think you almost have to have, you got excess reserves, but you almost have to have a growth reserve account. Because if you grow faster and if we can get that account, first your reserve account gets there, but if you really go to the moon, you need to have an extra amount of money in that, or at least have it available in situations where you get a call for all these tokens coming back, and you haven't had them around long enough to essentially get your 30 or 40 basis points, you know, and so that can put you in a crunch. So you need actually I think more than a 2% reserve, or some flexibility on the cap that the commission could say you go up to a 5% reserve with the commission, you know, so.
Through the chair, acknowledging the points from Commissioners Meyer and Pope, I do assume that when we look at the statute, we will need to look at that, the order of operations for the 102% reserve. Again, what was presented in statute that we approved today, or sorry, in the rules that we approved today reflects statute. But you're both touching on the reality situation in an instance where we grow quite rapidly. We're taking in dollars, we're investing them in treasuries. Those are earning interest, but you know, if it's 4% annualized, that means it takes 6 months of money sitting there not moving before we can hit that reserve of 2%, right? So if you game that out and say, well, let's put, you know, let's say we're growing well and we make $1 million if we have $1 million of issuance every day, you're never going to hit that buffer. So you result in these situations where hypothetically, and I do expect to present this to the select committee, hypothetically, we could be sitting on $1 billion stable token that's not returning anything back to the state, which is the intent, right? So I think we need to have a conversation with the select committee about, you know, kind of the order of operations about this. But at the same time, respecting and reflecting that we've had several conversations along the way about, you know, also upping what that buffer is, right? So maybe we just flip the order of things and dollars come back to the state or the agency first to pay for operations, and then we just reserve. We don't need to worry about returning things, but I think that needs to be a commission discussion as well as a select committee discussion.
Yeah, the only way I know to get more money is time. Yep.
Other questions?
All right, with that, I would call for any public comment. I'll go here in the room first. And do we have anyone online? With that, I will close public comment. And I think we got a lot done today. Good job.
Yeah.
And
Okay.
if no one has anything else, entertain a motion to adjourn. Is there support for Commissioner Wallace's motion?
Second.
Good job.
Okay.
All right, all those in favor say aye.
Aye.
Okay, thank you.
Thank you, guys.
All righty then.